Welcome everyone. We'll start our session for today. This is a Chavadi session, and for those of you who don't know, Chavadi is a non-partisan, informal platform that facilitates conversations between women litigators, and we try and offer sessions on issues of interest to specifically to women litigators, be it financial health, mental health, PoSH, arbitration, etc. A variety of reasons. And for the new faces, welcome, and we hope you'll attend future sessions. For the ones who've been here before, welcome back again. Today's session is, it addresses a very sensitive issue, and from 2013 has become a mandatory issue that most corporate workplaces or non-corporate workplaces also have to adhere to. There's a lot of statutory focus on that. There is a lot of chat in the media. There's a lot of, almost every year, I think from 2013, there have been one or the other issue that, that has focused around the PoSH Act. And while we have read about situations in workplaces, etc., as lawyers, we've probably have advised corporate clients, we've advised organizations, we've advised complainants, we've advised the accused or the respondent, and and represented them in court as well. But the nuances involved are something that we could all use a primer about, and our experts here who've all, I think cumulatively have about 45 years of experience, cumulatively, are here to take us through the various aspects. I'll quickly introduce you to our speakers. We have Shruti Vidyasagar. She's a lawyer and editor based in Bangalore with over 19 years of experience. She enrolled as an advocate in the Bar Council of Karnataka in Jan 2005. Since then, she's pursued a legal practice that involves advising on matters ranging from foreign investment, contracts, employment, intellectual property, and corporate compliance to women's rights, then prevention of workplace harassment, matrimonial law. She's also an advisor to various organizations in India on the law of prevention and redressal of workplace sexual harassment. Her work involves advising on law and compliance, drafting anti-sexual harassment policies, designing and conducting training, orientation and awareness programs, delivering specialized training for internal complaints committees, conducting inquiries into complaints, and preparing reports and recommendations for employers. Incidentally, Shruti and I went to the same college, but we didn't know each other then, though we were just a couple of years apart. Welcome, Shruti. Caroline Loba, our next speaker, she's a lawyer with over 18 years of experience, specializing in laws relating to corporate, commercial, sexual harassment, and gender sensitivity. In addition to providing corporate legal services, she's an expert in PoSH-related matters, and her diversified knowledge and practical experience enables her to consult clients to effectively implement the PoSH Act. As an external member, she helps draft PoSH and other HR policies, conducts PoSH audits, trainings, and handles PoSH and workplace-related complaints. Caroline and I also went to college together, but we do know each other extremely well. Nitya is Nitya Kalyani, our third speaker. She is an advocate with over 13 years of experience as a litigator, with a focus on commercial and civil disputes litigation. She runs her independent practice dealing with commercial litigation and matrimonial litigation. Nitya is also associated with SASHA from 2022, an organization that exclusively provides sexual harassment redressal and prevention services. At SASHA, Nitya has been an external member on PoSH inquiries and has assisted her clients achieve due compliance under the PoSH Act. Nitya is also an artist at heart and enjoys painting and has exhibited her work at Chitra Sante, the much-loved annual art fair. I did not know this till I was doing research on you. Nitya and I have history from court corridors. When we were waiting for matters to reach, we often exchanged Candy Crush scores. So welcome, panel, and I'll hand it over to you. We'll have the panel address us, and we'll open it out for questions. Yeah, it'll be a very interactive session.
Thanks very much, Nidhi. I'm very pleased to be here today with Caroline and Nitya. I haven't met Caroline at all. Again, strange are the ways of, I think, how alumni or even students at University Law College interact. But there we are. But I'm glad that, we've had a chance to meet now. And I do know Nitya from, more as a friend than as a colleague. But now more and more, we've had a chance to interact, But good to see you all here on a Saturday morning. When I told Nidhi that would be coming back from North America and I might be jet lagged, she said, Shruti, I think you can sleepwalk your way through this. I hope I'm not going to do that. So what we thought, the three of us, is, when the sort of the scope for this is that we're decoding the act, right? And that is really the scope of today's discussion. What I want to do is just set the background, little bit, not so much of the legislative history, but what I think of as what this law does and what it intended to do. And I want to warn you that perhaps some of what I say might seem a little too rosy, but we are going to address the problems and aspects that that have proved to be problematic or difficult or challenging as we've seen this law evolve over the more than the decade that it's been in place. But I wanted to set this background because to my mind, it's very important to remember the objective of this act, right? What it does. And however you might encounter this law, whether as a practitioner in terms of, having to challenge its implementation or just question it or see its role in as even as an activist, right? But for me, and literally today as I was thinking about it, it was very important for me to see it in light of the objectives and the struggles and the conversations and all of the events that led up to this, right? And so that's my objective when I, at least for the first 5 minutes when I talk about this act. And then I'm going to lay down the groundwork in terms of what is the structure, what are some important concepts and features. And then Caroline is going to talk about the role of an external member, and she's going to do that at great depth, right? And then we'll have Nitya talk about the inquiry process, what are some important aspects, what, as a lawyer, you might be called upon to advise complainants, advise respondents, what are those, what are some aspects that you will need to know. So that's the plan for the first half. And then we have a few more points we want to cover. But we don't want to stop you from asking questions. So after this first round, when we take 15, 20 minutes maybe to go through what we want you to know, happy to open it up for questions if that works for everyone. All right. Okay. So first of all, I think I'm sure everyone is aware of this law as a PoSH Act, or, I've seen also PoSH W Act, which I don't know how to use as an acronym. But nevertheless, PoSH Act is what we know it as. But it is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, right? It is a mouthful. But I think that pretty much sums up what the objective is, right? And again, as Nidhi pointed out, it's been more than a decade since it was passed, 2013 December. Now, some of you, if not all of you, will be aware of what sort of led up to possibly I would say almost, frenzied and hurried, the urgency which led to passing of this act at the timing that it did. So I won't go into that too much in detail. But I want to step back to, again, something that all of you will all be familiar with, the Vishakha judgment of 1997, right? Again, the background to that is the Bhamri Devi case, and many of us are familiar with it, and, all of us being lawyers in terms of having studied it under Article 21 and constitutional law, at least that's how I was introduced to it. So we are familiar, and later, we can talk about more details should you want to hear that. But for me, I like going back to Vishakha, right? because I feel, and if you read it and you know, as you practice, you read it, you tend to read it many, many times. It's short, the judgment, but it's actually very succinct in terms of what the objectives were, right? And for me, the most important thing was that it was a recognition of sexual harassment as a form of discrimination against women, right? And yes, you know, some of it was borrowed from various judgments of the US courts, but it was an articulation that sexual harassment in all its forms, in its various forms, and not just as an obvious form of violence or physical violence, right? But in its very many shades, that it is a form of discrimination against women, right? And it needed to be said, so I think it's very important that it was articulated in that way, right? In that sense, it was, you know, for me, that's very notable, right? And when the act was passed in 2013, certainly it's not the first time that the rights of women or rights of workers were being codified. We know that. But again, for me, it's very deeply important because it recognized that safety at the workplace. What does safety at the workplace mean? What must it include? And what it means for women who are looking to find their place in the workplace, right? I think that was also very important. Now, again, for me, going back to the Vishakha judgment, you know, the 1990s, the early 90s, when India was opening up in terms of its economy, it was expecting more capital, it wanted more people, and so you were expecting workplaces to be occupied by women. But what guarantees did women have? Right? Not very many. And it's sad that we had to wait for 16 more years since then for it to be codified. But at least, you know, the sort of, for me, the nebulous concept of safety, harassment, what do I want from a workplace, you know, not just, now workplace culture is a term we hear a lot and we understand, you know, we hear toxicity in the workplace, we hear, you know, so many things around culture which are considered soft, right? And these were not things that you immediately thought of. You were grateful to have a job, you were grateful to be paid, you were grateful that, you know, you probably were a permanent employee as opposed to someone just, you know, I can get rid of you like that, right? So when those quite tangible things you had, some of these intangibles tended to be forgotten, right? Or seen as, okay, this is something that's part of, you know, this is how I grow a thick skin. I have to deal with various kinds of people. So for me, for a legislation to think of it differently, right? To think of safety as beyond just physical safety, I think it was a brave thing to do, and it, you know, it's still work in progress, but I think it's a good thing they've done. Now, of course, it's gender specific, right? It's very deliberately gender specific. And I don't think at this point I want to go into, you know, any other discussion about gender neutrality and gender blindness. We can leave that for the discussions. But what I do like about it is that because it's gender specific and women centric, women oriented, it's also women led, right? And when I say it's women led, it's not just the obvious is that, of course, you know, more than half of the committee members, when you look at an internal committee, have to be women, or that the presiding officer is a woman. So in that sense, it's women-led. But I also think of it in terms of, look, this is how women can involve themselves in conversations, ask, you know, for that, you know, very often used term, seat at the table, and say, this is what I want. Right? This is what I deserve at the workplace. So in that sense, you know, I think of it as women-led. And I also think that, you know, I'm just going to say this one thing when it comes to gender neutrality. I don't think women are ungenerous enough to say that this should not include other people, right? And that's how I think of it. If it's a movement for rights, if it's a movement for safety at the workplace, right? Everyone is included. So whether we find this as the path towards achieving that or some other thing, that's, you know, to my mind, irrelevant, right? So I think what it did, the act ultimately, you know, and like I said, you know, to my mind, it said to women that you're important at the workplace, and it made employers take note of this, right? Employers had a tendency to shrug their shoulders, to say, oh, not my problem. I know these things happen, maybe you complain to the police, or, but we all know women had very little support, right? When you talk about access to justice, the barriers to women having to even convince people in their family to support them to file a complaint, right? We know how difficult that is. And so, if it meant shifting some of the onus to employers to say, these are the things that women want to take for granted when they come to a workplace, and we want you to assure them that they can take this for granted, I'm not going to quibble with that, right? I know there are people who have different problems with shifting burdens onto private, what is considered a state responsibility, shifting that. But again, that's a discussion for another day, right? So for me, it challenged the notion that employers were powerless, somehow that they could escape promising, this intangible comfort to women, right? I also think that this is very important because in many workplaces, I've seen the tendency to deal with the problem as, you go and complain to an employer. Then, are you having trouble? Okay. Is someone troubling you? Okay. Then I don't want this problem at all. So I'm going to get rid of you and the troublemaker. There's no question of looking to face the problem head on and solve it. It's like, I just want this out of my workplace, right? And so the Act said that's not something you can do because, you can't just get rid of them both and decide that I don't want the problem at all, right? So these are some things that I always keep in mind when I look at implementation, when I look at what an inquiry should do, what is really the purpose, right? And so these are for me very, very important. Now, in terms of the nature of the Act, it is a civil legislation, right? It is to be implemented at the workplace level, at the micro workplace level, in the sense that, every administrative unit, there is a requirement that every like I said, administrative unit of that workplace should have the committee, and everyone should be given awareness and so on, right? But the law is again very clear that the rights under this Act are not meant to substitute for anything else you may get under other statutes, but it's only in addition. So it gives women options, right? Now, in terms of the framework, essentially, it's about workplaces. So concepts of employer, who is an employer, private, public, state, organized, unorganized, individual employers, for-profit, not-for-profit, everything, everyone is included in the idea of the workplace and as an employer, right? And the way it's structured is that it specifically creates duties on the parts of employers, like I said, to create a safe workplace and what that means in terms of specific steps. And also, in that sense, rights to women employees in particular, to say this is what you can expect. And if you face a problem, what are the, what are the mechanisms that you have available to you to deal with, to seek redressal for your complaint. Now, when we talk about the mechanics and how this Act plays out, prevention, prohibition, and redressal, these are, again, the three main things that you keep in mind, right? So prevention through awareness. So it offers a way to sensitize people. It offers a way for people to have conversations around ideas of gender, ideas of, how gendered behavior can affect workplace cultures, right? So for me, this is not just about saying, oh, there's a problem, I have to deal with it, right? And some of you may be aware that, earlier, and I know a lot of us still say ICC as the Internal Complaints Committee. In fact, just within 3 years of, 2016, I think, there was an amendment that passed that changed the nomenclature from Internal Complaints Committee to just Internal Committee. And the reasoning was that we don't want to look at the committee just as a reactive body that looks at complaints, but also that they have a role to play in prevention And prohibition is, of course, it's laid out in the Act, right? So more active participation of members in prevention was the idea, and that was the reason for the nomenclature change. But in that sense, these are the three key elements, right? When you look at what ICs or internal committees are supposed to do, prevention and redressal both. And so, as Caroline and Nitya will continue, we will talk in detail about what are the ways in that it happens, right? Now, other important aspects and concepts that are very important to note, again, and to my mind, very important the way it's structured, is that there are inclusive definitions of both sexual harassment and workplaces, right? And so, again, this is something that come COVID and all our remote and hybrid work, we all, appreciated a lot that we didn't have to, do cartwheels to find ways to extend naturally the idea of the workplace to include these remote virtual meetings and so on, right? And so that was far-sighted. Of course, not so much that we imagined a virtual world or there would be so much interaction by virtual means, but I think just the real sense of how Indian workplaces can extend beyond just concepts of offices, right? And that is another very important feature of this statute, that it kept the unorganized worker, even the domestic worker in mind, right? Which many of us now tend to forget because our practice becomes so corporate and we have this very specific idea of an employer being an entity or an institution or a company, but that's not always the case. Again, we will talk about how local complaints committees are there for the unorganized sector, whether they're working or not, and what we can do as lawyers maybe to encourage, more publicity into that. But certainly in the Act, the intent was always there. And so I think it's important not to forget that, right? Sitting in Bangalore, advising, corporate clients who've really just internalize this now as part of their checklists, it does seem like it's worked very well. But, when you really sit back and reflect, not so much. So that's something I wanted to highlight. But the inclusive definition of sexual harassment and workplaces is very important. Again, the definition of sexual harassment is inclusive. And while, it makes people very, men especially, they feel very worried and alarmed at, how you can interpret it in any way. This is so subjective. Welcome to our world. So, I think it's a recognition of how sometimes even it is so difficult to verbalize what you're going through, right? And I think for the law to recognize this is a huge thing. It's a huge thing. And I really think that it would not have been as effective had it been, a very specific definition. Now also we do this, is it sexual harassment? Is it only workplace harassment? What is sexual? What is... So we go into all that. And those are important ways for us to analyze and understand behavior. But for the legislation to do this, and that it's stuck this way, and we are continuing with this, and there's been no discussion for any change for this kind of definition, and I think that's it's a huge thing. And on the definition of employee as well, to include interns, to include volunteers, right? So it's agnostic of remuneration. It's agnostic of what legal status you have. It's agnostic of whether you have been a long-term employee or it's day one. These are also very, very important things. And these are those inclusive elements, right? Making everyone feel equally important in terms of saying that this is my workplace also. And I have as much right as anybody else to be dealt with in a particular way and to not be dealt with in a particular way, right? And so, again, as we talk through, we'll talk about definitions of employer, employee, sexual harassment, workplace, how it extends, right? And in terms of, for employers particularly, in terms of prevention and redressal, there are very specific steps to be taken through the running of through the setting up and running this program through an internal committee. Again, the idea that you, made it so A, women-led, right, number one. B, that it was a group of peers, right? Which is also, I think, a novel idea, right? That yes, you had, probably disciplinary committees and so on, as part of internal mechanisms, but that was always looked at as HR or, compliance, or a specific department had to work into that. But here was a group of people intended to be as diverse as possible, including an external, who was going to bring in, yes, neutrality, impartiality, but also their own view of what gender dynamics could be and should be, right? Again, this was quite a novel step, I think, that the legislation took. And again, it led to conversations around how involved you can get in putting in place workplace culture, right? And I think this is a very important step for people to feel involved and invested, right? This is not a top-down thing, right? And I think it's sort of a democratization, to my mind, of how workplace cultures can be developed, and both at the micro level and at the macro level. So that's also very important. I will again leave it to Caroline to talk more about the structure, composition, the role of the external member, and so on, right? So, to sort of sum it all up, I think for me, the Act is really a tool for access to justice, right? And I think both are very important to remember. The fact that it's a tool in that it is an instrument, but also justice, right? I was reading somewhere that, equality without justice is sort of meaningless. And I think we do need to keep that in mind. Whatever we understand as the role of the statute in, the mechanics of the inquiry process or whatever that is. I think as justice, equality, inclusiveness, these are really important things. And for me, this statute is a way to bring about those things. The statute, the way you work it, the way the internal committee functions, and the role of the external member is also to then create opportunities for conversations, right? To sensitize people, to bring on different perspectives and viewpoints, and also to have articulation of voices and viewpoints that were not heard before, right? And also, most importantly, accountability, right? And visible accountability from, people who earlier were thought to be too powerful, from whom we could demand accountability, right? So for me, these are some important aspects of the Act. And that's why like I said, it may seem very a rosy picture, but I'm very hopeful of, and I'm very invested in talking about this more and more as a way to grow that inclusivity and equity and diversity and all of those bywords that, we hear a lot, right? And I think, as Nidhi said, in terms of your engagement as a lawyer, whatever way it may be, whether it's because you're called upon to advise a client, whether it's because you are advising someone about implementation, or sitting on a committee as external member, right? I hope some of these thoughts, help you in and sort of guide you. And for me, these have been very important ways in which to see my role and how, I fit and what my job should be under the law. And I hope you found these useful. Let me now pass on to Caroline.
Thank you. Thank you, Shruti. Firstly, again, wonderful to be here. Thank you, Nidhi, for this opportunity, and wonderful ladies beside me. It's so lovely to see women, actually, because for the number of years that I've been working as an external member, it's rare that we see only women. Unless it is made mandatory at the organization where they say that both genders have to participate, we usually see women coming in. Yeah, but we do have it for all, so it's mixed. But to see this forum only with women, it's really, really encouraging and good. So before I get started, I just wanted to know, do we have any external members in the crowd here? The back we have? No? Okay.
Aspiring.
Aspiring, yeah. I'm sure they'll become after this panel discussion. Definitely they'll want to be So that's wonderful. And also, actually, thank you. We have one gentleman also among us, so hopefully he takes back something from here and then spreads it to the others also. So I won't straight away get to who the external member should be, right? She's taken us through the scope and applicability. The first thing for any organization, as we all know, would be to actually have an internal committee in place. Who are the internal committee members? That is very important because that is again somewhere where we usually support and guide them in actually having an internal committee in place and who the people are. So the presiding officer, the person who will be leading the team, has to be a lady for obvious reasons that the law is made for women. So they would want someone at the head of it who is a lady. And they also say that that person should have a lot of experience in that organization. Older, probably not just age, but even, with being in the organization, they're wiser. They understand the nuances of, the line they're in, the company, the functions, all of that. Apart from that, you have to have two other members. Yeah. And usually what we do, it's again not given in the law, but we say let's keep it gender neutral. Have a gentleman also on the board. Any reason why you think we need to have men also on board? Appear to be fair, yes, absolutely. And the respondent many times, most times or whatever, is a male member, right, of the organization. So they probably feel more comfortable if there's another male person sitting across them. That's the reason actually they say that have a male person on the internal committee. And then of course it comes to the external member. The external member, according to the Act, obviously, they say it should be someone who's worked in an NGO or who has an understanding of sexual harassment against women. Now, if you see those terms and if you see the Act that she's actually having, the BEAR Act, it's just a 13-page document. And when it was made, it was the need of the hour. So it was like almost overnight they came up with the Act. So descriptions, do's and don'ts, all of that is not really put into it. But in time and with practice, a lot of us are bringing changes which are not going against the Act, but at least aiding and supporting organizations. Because at the crux of it, our main aim is what? To obviously protect women at the workplace, right? So to help that, we try and change few things here and there so that it will help in the functioning of the internal committee. So it's gone beyond, just being fair and unbiased and all of those fancy terminologies, because you're not just born fair and unbiased. We all come with that being biased at some point or the other. So again, this takes time, this takes practice. It's taken me time and practice. I'll speak for myself. Being fair, I don't think I ever thought if I was fair, unbiased, unjudgmental. I have been judgmental, I still am. But these are issues when it comes to a matter, when it comes to inquiry specifically, not just being an external member for other issues, but when there's a matter, a case in front of you, it means so much. Because when there's a matter and an inquiry, you're conducting the proceedings or examination, chief complainant respondent, I have seen where there are the IC members who ask inappropriate questions, and it's not their fault probably, because they don't understand. When you give a training, you don't get into the nitty-gritties of your behavior. You just talk about the skeleton of what should be done, shouldn't be done, follow the Act, follow your company policy, and that's it. But when there's a case that comes up, that's when you really see what actually happens there, right? Simple example of even seating position. I've seen an organization when it was my first inquiry where all the IC members are sitting on one side with this stern, angry face, even with the complainant, and the other person who's coming for the examination is made to sit on the other side. So again, just have a blend. Let them sit amongst you. Finally, they are one of us, right? We all make mistakes. And here we are only as a corrective measure. We're not taking punitive action against these people. It's not the court. That's why the internal committee also, or the PoSH Act, actually came into existence. So from that perspective, if you see, the external member goes way, way beyond just being fair and unbiased. Yeah, even your questioning, do not ask direct statements, or leading questions like they say. But that is done many times. Like you say, oh, you do this to your brother, is it? You do to your sister, your mother? What if that lady was your sister or your mother? These kind of questions actually have come out in the open. And you can't stop an inquiry and correct the IC there, obviously. So in time, you make notes, you start learning, and then you just keep getting better. I'm sure the external members here present also will agree on such things. That one thing, then the other thing that is actually, not really rumors, but discussions going around is, should a lawyer be an external member? Yeah. Again, there's an act. In the act, nowhere there is advocate, lawyer, legal experience. None of that is given. right? So some person who wants to become an external member takes the act, they'll say, yeah, you don't need a lawyer. We have a 13-page document which anyone understands, it's in regular language. Why can't anyone else be, and why it should be a lawyer? So we were also discussing about this, and there is actually, I have come to realize that some places, not all times, sometimes I think a lawyer brings in a different flavor to the organization, just not with inquiries, but even with guidance of policies. When they give you policy vetting, there's a different kind of recommendation given when it's a lawyer or otherwise. Yeah, and most times it's seen that when it's a lawyer's recommendation, it is more detailed. So we don't leave loopholes and gaps of what if this happened, what if that happened. Those kind of instances most times are covered when it's actually a lawyer looking into those policies. Trainings. I think from lawyers, you give from a legal perspective also. We don't cite sections and acts and all of that, but examples of case study, all of that. Again, from a lawyer perspective, it is quite different. We have seen on groups on which we are, the PoSH groups, which we WhatsApp groups, the discussions when it is from a lawyer perspective and a layperson's perspective, again, is different. Now, today's crowd, if we had non-lawyers, I'm sure this would have led to one fight, an argument, and then Nidhi would have had to actually break it up. But I think today, because most of you are lawyers, I can, or all of you are lawyers, I can say that openly. The other thing is also the scope of the work as an external member, which it goes beyond inquiries, right? When we started this, it was just to handle cases, which means that only as an external member, you have to only go for an inquiry when there's a case that comes up. You had it start to end, a report is drafted, recommendations are given. And now it's more like, your saloon packages you get, waxing, shaving, and haircuts, and spa, facials, all of that, okay, 1,000 rupees. Most of the time, the external member, this is what is expected. There are rare, organizations which come and say, we want you to only step in when there's an inquiry in place. Very rare. It's mostly from the start of where they actually ask you to do the policies, vet the policies, then they ask you to also do the trainings and be on the panel for the inquiries, and there's so much more. Annual reports, again, something that we were discussing. Annual reports is also expected to be, first of all, drafted by us, signed by us, and actually gone and stood in line like at the government office to, sir, please, Tokali, sir. And the first time I did that, I was questioned as to, Yarama nivu? Because they said, so what if you're the external? We don't want to see the external. We want to see someone from the organization. So they assumed that I was being paid just to, put that signature and seal of a lawyer and just hand it over, which meant that basically that organization didn't have an IC. That was the assumption of the people sitting there in the labor department. So all of the, apart from annual reports, I think everything else an external member does. So much so, even small things of, there's a matter that has come up and they say, it's actually not sexual harassment, it's a domestic inquiry, but little help from your legal background, you can just tell me, how to draft, how to go about it. We don't have a committee. Will you sit in that committee also, please, for us? So we have really stretched it, not realizing we've gone beyond actually our scope and, what we are supposed to be doing there. But that depends on person to person, how you take, what you take, and what you are accepting to take on board. The extent of liability on behalf of the company, like I said, the annual report, we should not be going that far. It's not required, and also they've made it very clear that you all are not needed there when you're submitting the annual reports. But that apart, when there is a matter, an inquiry, and the end result, you submit the report, there are times where one of the parties, one is always unhappy, right? We can't make both of them happy. So not like we're there to make them happy, but yeah. And one of them who's not satisfied with the outcome or the recommendation, they come back to the internal committee. An internal committee comes back to the presiding officer comes back to the external member asking us to now what do we do, right? Because the appeal, which means according to the act, is not within the organization. Yeah, but again, this is another step organizations have taken just to help the process, just to keep the matter within the four walls. They have an appeal internally, which means that one of the directors or someone is taking the appellate authority position. So there again, the presiding officer is asked for guidance and support and, how do we go about it? What do we do next? The letter of suspension, can it be drafted by us? Termination, can it be done by us? So it's much, much beyond what is expected. And I think we are actually giving into that role also, which also is making organizations comfortable to take us on. Otherwise, they're always having this hesitation of if it's just inquiries, we don't have inquiries. Yeah, maybe probably it's being hushed up or, pushed under the rug. We don't know about that. We can't get into that. And if there are issues where they say that, managers have spoken to presiding officers, directly called us, because sometimes our names, email IDs, telephone numbers are put up on these posters. So they call us directly and say, see, this is a very petty, small matter. We have projects going on. We can't allow these employees to, come for inquiries and then be suspended or work from home. We can't be affording to do that. Can you just talk to that person? Can you just come to office, speak to the complainant respondent, and just, patch things up? Obviously, we're not going to be doing that, but these are the kind of inquiries we get time and again. So how far we're going to go, it depends again person to person. But as lawyers, I think it will be good to know, what your limits are. Today, there hasn't been probably any action taken against external members who have stretched beyond their capacity or scope. But you never know when there's actually a day where organizations are pulled up because your presiding officer acted over and above their scope. So that one thing, and then also compliance. When we tell organizations this is a compliance, a statutory requirement to have internal committees and PoSH Act in place, many of them now, not the bigger ones, at least the smaller, the startups, that's where the struggle is. And there are so many startups budding right now in Bangalore. The challenge is they're always coming back and saying that we don't have that many women, we just have one lady, or we don't have ladies also in some instances. We have 10 men or 9 men, and there is no lady at all. So why should we actually be bound by this? So do you all think actually that that such an organization should have an internal committee in place and a PoSH policy in place?
Should we have it? Yes.
Should we have an internal committee, but?
Especially the men, employees from it. They should have a policy.
Okay.
I think it's more also because sensitization to men also. Like if there is an internal committee in place, then they will have to be dealing, they're complying with the act, and they'll be made aware in male employees.
Yeah.
So if for nothing, even in anticipation, at least the men during that period will be maybe more sensitized and aware of what the act itself.
Absolutely, yes.
There can be a visitor who could be a female, and if she faces
Yeah.
sexual harassment in a particular organization, then there has to be a committee to complain.
True.
And also not
I
to make
agree.
a generalization, but usually the domestic help in offices would be a woman, at least in India. So even for her, wouldn't she also
Fall under the bracket. Absolutely. You were saying something.
The same.
Yeah.
The definition of complainant is very broad, so it can deal with it.
Absolutely. Yeah. See, again, going back to the act, right? It was made almost like overnight. It's really, really flimsy act, and I don't think they put in that much of thought process into making all the act, the rules, all of it. So it is us now today who are bringing in these changes only to benefit people, organization, and both genders. Someday soon it will become a neutral gender policy also. That's what we are aiming for. So like most of you said, it is important. Apart from the policy, it is important to actually have an internal committee. Most of them forget that the housekeeping is women also. Now you even have cab drivers, auto drivers who are women. So if you're going to be taking an auto or a cab to a client place, that becomes also your workplace, right? So what if something happens there? Then who do you go to, right? So that's why it's always important. We've told them, even if it's 9 employees today, and these startups are growing by the hour or the second. So today they could be 9 when that person spoke to me. By evening, they would have hired the 10th or the 12th, right? So we always tell them not to risk it. If we don't know about it, if I'm unaware of it, I just leave it. But if they've come to me, I always tell them, have an internal committee in place. What will happen now if there's an internal committee, they want to actually have an internal committee in place, but they don't have enough members because it says, right, 50% has to be women in the internal committee. Then what is the recourse? What do you do then?
Section 4 say that can also be people around other potential to see okay.
Yeah. What if I don't have another branch or any other entity, nothing? It's just an independent organization that I'm starting a company.
But
True, really, because there were two organizations which went back and said, because they were really keen on actually having all the statutory, compliances set in place. They said, okay, now we are this number, but we will ensure the next that we're looking out for will be women. They've of course not gotten back, but yeah, they did say we will look out for women and get women on board so that they can take on these roles, right? So that is about the external member. Now when it comes to functioning, like I've already told you, it depends how far you want to go with your organization. Fair call. With inquiries, we have to be very, very cautious. Other things are sidelined, that's absolutely fine. With inquiries, you have to be extra careful. There were cases where during the inquiry, the presiding officer or the external member or the internal committee members have just said, it's getting later, I have to leave, or my auto is waiting, my husband is waiting, he won't wait long, I stay too far, I have to leave. And these are situations that will come up naturally, right? Or I have a pressing meeting, but we cannot leave midway. We'll have to stop the inquiry and then actually, close and start another time. But we've had these instances where it's been taken lightly and nothing has happened. Few weeks later, because confidentiality is not actually confidentiality, everyone actually starts getting to know what has happened. Some third person from the organization got to know that this XYZ person, presiding officer or external member or IC member, had stepped away twice or thrice, even if it meant at the fag end of the inquiry, right? And was not a participant to the complete inquiry process, so it cannot be actually allowed. So they had to start the whole thing again. So these are things that are coming up, even though we are trying to make changes and it's going to be challenging, but these are instances that will keep coming up, and I think we should be sure as lawyers and women who will be taking on external member roles, we should be very, very thorough and sure as to what steps we take. The Act does not define it. It's only through practice and talking to other external members that you get to know of these little, steps that you should be following through. That's about it, I think. I think it's...
There's certification or something that lawyers can undergo become an member, like any thoughts on that?
Yeah, so certification, the Act does not say that you should be a certified external member or you need certification to become an external member. It only adds to, your functioning as an external member that you are certified, but more so, it's more of practice if you have the understanding and the maturity and the non-judgmental attitude to take it up. So far, personal view, this is all right. I'm sure others may say differently, but I have not seen that if you have a certification, that it helps better than a person who's had tenure just being an external member, lay person or legal person. So, yeah.
Sorry, Nitya, I'll just take a minute to add. So I think it's important to recognize, Nitya, there's no body that actually is authorized to give out any certificates. I think that we need to recognize because, potential clients will ask you because they see that, there are all these consulting agencies or, collectives of lawyers or, HR folks, because this has become a compliance issue, right? And everyone's catering to corporates. And that's where the money is. Let's be very, very clear about this, right? So they are going to, there is now, it's a very busy market, right? There are many visible players. So how do you distinguish yourself? You say, I have a certificate. And so then that becomes the ask, do you have a certificate? Are you certified to be a trainer? Are you certified? So, but there isn't, there is no ministry. At one point, the ministry, the Union Government Ministry had this empanelment process, but that has now been suspended. However, you will still see a list, and I still have potential clients who are possibly NSE or BSc listed and say, Madam, are you empaneled? I say, no. I mean, where am I supposed to be? And, they go on, I go on, it's fine. But I think it's important to slightly push back on that and say, there isn't a requirement. Why are you coming to me as a lawyer? And I just taking off from where Caroline left, I think there are some very key strengths we bring to the role of an external member, right? As a lawyer, at least this is how I think of it, you're a natural skeptic. And that skepticism is important. As much as you're required to be sensitive, right? If you're not skeptical, I think you're doing an injustice to the role, right? Because the facts are never as you first encounter them. And when Divya said, to appear to be fair, Of course, you have to be fair, but what does fairness mean? It's a combination of, to my mind, integrity, neutrality, objectivity, very importantly, and questioning, questioning, questioning. Every time you'll have to push back against the committee also, because they will say, oh, this is the complaint. Now we gave it to the respondent. He's given and I'm just going to say she and he, because most of the time it's she and he, right? And oh, he's admitted. I said, okay, but has he admitted fully? Are there any qualifications? Is there any explanation, exceptions? I said, no, it's on paper, why don't we close it? I said, no, I want to understand how we ended up in this position, right? What are they admitting to? Why are they not admitting to the other things, right? And these are things that it is very important for us as external members to push back, because there's always going to be pressure, and believe me, cost pressure is one of the most important things that you're going to have to absorb, right? And you say that, I'm spending time, that's it, but I am going to at least advise you to do this, because otherwise I would not be. So, like I said, as a lawyer, skepticism and the importance of documentation, right? As Caroline mentioned, the Act says the quorum for a proper inquiry proceeding is 3 people. Now, the presiding officer specifically mentioned in the rules, and at least 2 other people. So conveniently, people will say, no, external member is not mentioned, so we don't need you. I say, then then your committee itself is wrong, right? If you're, for a proper committee, for it to be validly constituted, if you have an external, if you don't have them as part of your inquiry proceedings, what is their role? Are they going to sit and read your documentation and give you marks on that? I mean, what is the point of having an external member, right? So I make sure to include in policies to very clearly say that inquiry proceedings, the proper quorum is, you want to put the number at 3, I'm okay with that. Make sure presiding officer is mentioned, because that's it's specified in the rules. And I say external member. And I say you make this is important for your organization, it's important for complainants and respondents also, right? So documenting that, right? How do you document minutes? Again, I'm sure Nitya will talk about, inquiry proceedings, whether it's first person, third person, leave all that aside. Date, time, who was present, who was absent. These are things that we are naturally, I hope trained, documentation is a forte, right? And, as much as sometimes as external members, we quibble and we feel uncomfortable about, oh, this is so burdensome, they make us do it. I am comfortable doing it because I know I will do a much better job than somebody else, because the committee is going to be held accountable, right? And if my name is going on that report, if my name is going in the minutes, I want to make sure that everything is done properly. It does not matter to me if you are going to get someone like a stenographer or some administrative help who's going to, look at, I still want to look at the minutes. So I think these are qualities that lawyers naturally bring to the table, and these are our strengths, right? And the ability, like Caroline said, to be a little more forethought. We're always looking at, we are drafting for the bad days, right? When we were thinking of drafts, like, excellent if this happens, but what if it doesn't? What then, right? And so you're covering those gaps, right? And, even practices such as, oh, yes, you've talked to the complainant, but have you told them what their rights are? Yes, but then tomorrow she may say, no, it never happened, nobody told me. So then document that conversation, right? So these are the things I think that become very important, and these are our strengths. And I think that's where our role becomes much more important as lawyers. I will just say one more thing before, handing over to Nitya, who's been waiting. I think, the other most important thing that I have found, we talked about how outcomes may not to be the liking of one or more party. That's fine. That I can live with, right? What my expectation is, and expectations that I have from my fellow committee members, is that people who come to us come with an expectation that they will be dealt with fairly, properly, in a very dignified way, right? And it's not so much that your decision has an impact on their career. Yes, it's going to. That's a no-brainer, right? But how did you make them feel through the process, and what will they remember when they, go back and think about how you dealt with them? I think that is very important, right? Stern faces is fine, being strict is fine, being tough is fine. But are you giving them the opportunity to speak? Are you giving them that sense of dignity that, yes, we are here in some ways at the end to judge your behavior, but we are not judging you, right? And I think that distinction is very important. And therefore, these are also things that external members have to lead by example, right? Many of the other internal committee members may not come with that sense of sensitivity, and this is something we have to develop and say, if that works for you, I insist that I take the lead in questioning. I insist that I prepare the questions in advance because there is a certain flow to it, and I want to say certain things. I set the tone quite literally because I want everyone to set the same tone, right? And because for me it's very, and this I've learned the hard way, right? You go with it with a lot of swagger, with a lot of, I'm here to do this. But you have to remember, at the end of the day, these are people, right? And they all have to continue to work with each other. I will walk away, right? And so sometimes I have to take on the role of bad cop, but everyone else still has to continue to work. And so that is very, very important. And if you need to have conversations, discussions, and prepare prior to talking to the parties, it's always a good idea to do so. So let me hand it to Nitya now, who's been waiting very patiently. And maybe once she's done, we can go to more questions.
Yeah. Thank you, Shruti. Thank you, Carolyn. Thank you, Nidhi, for giving this great opportunity to come here and talk to my peers about this. There are two things that I wish, hope to cover in this session. One is quickly to go over what an inquiry process entails, because as an external member, you're going to be a part of several inquiries. So how this plays out, what are the ingredients of it, what are do's and don'ts. And also I want to discuss the fractions of services that us lawyers can offer within the realm of the PoSH Act, right? As an external member, as, there are clients who come to me for advice as complainants or respondents in the inquiry process itself. And there is also the appeal stage where you can be fully involved. So I will cover these aspects. Now, before I get into the inquiry process, obviously jurisdiction is something that we have to address, because as an external member or as a part of an internal committee, when there are complaints that are received by the HR, more often than not, there is some confusion as to whether or not it is sexual harassment, because there are elements of workplace harassment, there are elements of discrimination based on gender, and these issues often overlap. And only if it is sexual harassment can the internal committee handle it. And also the limitation, as most of you might know, is that it's 3 months and it can be extended up to a period of 6 months. And once the internal committee starts the inquiry, the prime factor in the mind of the internal committee members that must always be remembered is to comply with the principles of natural justice and to be as unbiased as possible. When you go into an inquiry, you don't assume the guilt of the respondent. You don't automatically side with the complainant. It's a delicate balance. You have to be as neutral, independent, and unbiased as you possibly can be. And it starts with collecting a email or a written complaint from the complainant, and it has to be forwarded to the respondent. We have to interview all the witnesses that are mentioned by the complainants and the respondents, and then come to a finding on the whether these allegations are proven or not. But throughout this entire process, in fact, there are sometimes that I see very often that companies slip up on this when they withhold information regarding a complaint. Okay, they sit on some on complaint, they withhold certain key elements of it, and then they share it with the respondent, or they don't share witness statements with the respondent saying that they want anonymity and therefore we're withholding it. Those are things when the respondents will definitely challenge the recommendation, the report that has been made, and it will not stand the test of principles, complying with the principles of natural justice, which is very important. Also, what I think we need to bear in mind throughout this entire process, I know I'm going on saying neutrality several times, but trust me, especially people who are not external members in the internal committee, they can be extremely ignorant of how to deal with complainants and respondents, right? Of course, the policy is gender specific, but a lot of companies have moved on to a gender neutral space and they make it inclusive that anybody can file a complaint. And when, in fact, in one of the instances where a male employee had come with a complaint of abuse by another male employee, the first question that the internal committee asked this person was, "Are you homosexual?" to the complainant. Now, had the complainant been a woman, they're not going to question what her sexuality was, right? So there are these little things, nitty-gritties that obviously we are hoping that will neutralize over several trainings, capacity building sessions for the internal committees, all of which is within the purview of what an external member does for a company. This is an overview of the inquiry proceeding. Now, at the end of the inquiry, before we get into the inquiry, there is something known as conciliation. A conciliation is when the complainant is okay to accept the apology of the respondent and an undertaking maybe that they will not conduct themselves in a certain manner, and willing to close the complaint at that stage. This again depends on the severity of the allegations that are being made by the complainant. When the complainant says, that somebody expressed a romantic interest and when they said no, later the person's very apologetic, sometimes they're willing to compromise, they close it with a settlement. Going back to the inquiry process, another thing that is important for, I told you that they have limited powers of the civil court, right? They can summon witnesses, they can speak to complainant, respondent, etc. They can also give any interim relief for the complainant, because a complainant is not expected to work with the person who is alleged to have conducted themselves inappropriately with her. So they can separate their work relationship, they can give paid leave up to 3 months, they can transfer these people, make them work from different branches, make one of them work from home. Such provisions can be done. At the end of the inquiry, and if conciliation doesn't happen, the inquiry starts, and never can monetary element be a part of the conciliation. Okay, I will speak a little more on conciliation where there is in fact a monetary element. How do we navigate that? Because that's within the purview of the kind of service that a lawyer may be expected to give, because I get inquiries like that. But before that, to conclude on this inquiry process, there are 3 outcomes from an inquiry. One is when allegations are proven against the respondent, right? That we find, yes, of course, this person has committed the act. And 2 is allegations are not proven, where there is not enough evidence to prove the complaint against the respondent, but that in itself is not a cause of action against the complainant. It's simply a complaint that can't be proven. And then there is a false or malicious complaint that is done by the complainant, knowing for it to be false or fabricated, in which case there is action that is taken against the complainant itself. There is a recommendation made against the complainant. Now, once the committee arrives at any of these findings, especially if they find that the allegations are proven, they can then make recommendations to the employer. This could span from, have them undergo counseling, withhold their promotions, increments, bonuses, have them transferred. In severe cases, they will even be terminated from the employment. That's why it's really important that the respondent is always an employee of the company. And the complainant can be anyone. It's it's sweeping and inclusive. Coming to the kind of questions, inquiries that I get as a litigating lawyer who's also in the field of prevention of sexual harassment, one is so one of the complaints, sometimes clients come to me asking if, most often I get queries about defending these complaints that have been filed. Now the Act, as you will see, doesn't allow for legal representation before the internal committee. But that doesn't prevent them from coming to lawyers, and it doesn't prevent lawyers from giving some back-end advice on how they should go about it, what are their rights, what can they expect. When the complainant comes, you help them draft the complaint, you vet it at each step, what is going on, how is the internal committee treating them, are they getting access to internal relief, do they know their rights, that they can also, because this act is in addition to whatever other remedies there are in law for the woman, it's not in derogation of it. So one could file a complaint before the internal committee, and they could also file a complaint before the police station for any offense under the IPC. This is something that the internal committee has to inform them at the get-go, that they are entitled to these reliefs. Now, when these back-end kind of assistance can be given, and when the respondent approaches you, you can make sure that they have access to all the allegations that are made against them, all the proof that is there against them, all the witnesses' statements that are made against them, everything that the respondent has to have access to. And sometimes there is also an option of cross-examining the complainant and the witness. More often than not, complainants and witnesses are not comfortable being cross-examined by the respondent or the perpetrator of the alleged offense. So in those cases, what we do as the internal committee is we ask for these questions to be in writing from the respondent, and we put it across to the complainant, and vice versa. So those are also things that lawyers will have a better holding on how to structure these questions, how to design the cross, what do we elicit, what are the admissions that we need to get. Now, after the inquiry is over, the report is drawn up, recommendations are made. The law provides for appeal to be made against anything. Recommendations that are, based on the finding, whether or not allegations are proven, how the evidence is considered, what are the recommendations that are made, and there are some miscellaneous provisions also that, confidentiality has to be maintained. These aspects cannot be published. If there is any violation of that, in that case also they can file an appeal. The appeal is before the Labour Commissioner in Kandaya Bhavan, in Bannerghatta, in Bangalore, specifically speaking. And in so like Shruti and Carolyn were saying, for all organizations that have 10 or more employees, they are supposed to have these internal committees. They are supposed to have a redressal mechanism. But in the unorganized sector, where there are, domestic workers, etc., and they can't file a complaint, or it's against the employer itself, then they can approach the local complaints committee. Now, the three of us were discussing how mysterious the local complaints committee is, because before this talk, I even called up the State Women's Commission to find out who are the members of the local complaints committee here in Bangalore, and I could not find an answer to it. If anybody in the audience has an answer for it, I'm, grateful for it. Yeah, because it's a really mysterious body. There is no clarity on it. At least in some states like Gurgaon, Andaman, they have a list of the local complaints committee members, and there is a she-box. So there is more access and approach, there is more awareness. But here, there is zero insight into who the local complaints committee are, where do they sit, how do we file a complaint to them. They say, come to the State Women's Commission, illi complaint ಮಾಡಿ ನಾವು ನೋಡ್ಕೊಳ್ತೀವಿ. ಇಲ್ಲಿ complaint ಹಾಕಿದ್ರೆ we will take care of it, and you have to go through that route. You have to go through the State Women's Commission, which you can approach at near Civil Court on KG Road, or there is, I believe near Nimans, there is another unit that you can approach. So once, so this local complaints committee is totally mysterious, ambiguous, and in fact, how many of you know of an internal committee that exists in the civil court framework, in the high court framework, in Mayo Hall, right? Did you even know that there is an internal committee that you could go with your complaints? Because as litigating lawyers, I'm sure that we face, a lot of us must be facing some kind of, subtle or not so subtle forms of sexual harassment. And please note that if this happens in civil court, you can approach the internal committee of the city civil court. It is not necessary that you have to be in the admin or employment of the civil court. And similarly for the other courts. Somehow, even though I would think that we are one of the most empowered factions of women in the society as litigating lawyers, and we know the law, we know how to go about this. I feel that there is some kind of restraint in filing these complaints, some kind of restraint in going ahead and addressing this. Therefore, it's not just awareness, but it's willingness to take action based on what you know that comes into play here. So, and conflict areas, and another thing that I told you that I want to cover is conciliation. In fact, one of these respondents approached me who very clearly had sexually assaulted another employee, female employee, and they came to me and said that, hey, you know what? First they came all gung-ho, I want to defend this, there is no way, how can she prove it? There is no proof, only we, both of us were there, there's no way that she can prove it. I mean, consider the audacity of this person coming and telling me this. And then finally I said, if you have done this, I would suggest that you put your papers and go about your way before it gets worse for you. And so somehow there was some negotiation, and the complainant in this case was agreeable to receive a certain amount of money to be able to withdraw her complaint and let this go. Now the act says that a monetary element cannot be a part of this settlement. But in our Western counterparts in US, etc., more often than not, there is money that is given as a part of these settlements. So the respondent will not speak, I mean, the complainant will not speak against the respondent. We even know many, world leaders and politicians who have entered into similar agreements. So the way that I worked it, because it's not allowed for you to enter into such a settlement under the Act. But there are, the way that I navigated it is that I sort of addressed it as a workplace issue that was being resolved and is being closed. And the committee also, they didn't take the settlement on record, okay? But the complainant is the master of the ship. She can withdraw this complaint at any point. So a simpliciter withdrawal was done before the committee and the case was closed. Now, it's again a moral conflict, right? You're thinking, is it okay for her to accept the money? Should I be facilitating this? But at least the way that I saw it was, good, he's paying for it. You know, at least he's paying for it. It may not make up for the trauma that he has caused this person, but there is some more concrete, and he also was asked to quit the company anyway. So she achieved that result with the settlement, and therefore I kind of helped her navigate that. That's all I had to say, but the three of us are open to any questions any of you might have in terms of anything that we discussed. Right?
Yeah, yeah. You want to pass the mic around?
Before I open it out for questions, I just wanted to ask the panel to just cover two things. Nitya mentioned workplace romance, so we'll start on that.
Yeah,
it's
I'd
a
love
very
to cover that.
It's a very common way. I'm sure in this audience, several of us have, though not me, but several of us have met our partners at our workplaces. So with this now, before Tinder, Bumble, OkCupid, etc., it was wherever you worked. Lawyer, yeah. Engineer, doctor, right? The whole, I can see several here. So how do you advise companies to implement policies, specifically, as an external member, how do you maintain interpersonal relations between colleagues? That's one. Then this is specifically for Nitya, which is how do you manage to be active as an external member while being a practicing lawyer? For those who are interested in getting into PoSH work. And to the panel generally, what are the consequences that employers may face if they don't act on the recommendations of the internal committee? Yeah. And I'll give this to Divya after you finish.
Sure.
Go ahead.
So when workplace romances are concerned, one thing that you need to always remember is there might be a power dynamic at play here. Is this a relationship between peers, colleagues? Is it a relationship between somebody who is, hierarchically in a different place than one of the persons? In which case, what I have advised companies, Shruti and Carolyn, I don't know how you navigate it, but I have advised them that they should have a policy where, office romances are bound to happen. We can't restrict them, we can't ban them. But especially when there is a power dynamic involved, I say that it be declared there's a form that you declare it to the HR that such and such a person is involved in a romantic relationship, if they should so choose. Because a lot of our complaints that come once the relationship has broken up and there is discord between the parties, then it turns into a complaint and comes to us, and it becomes very tricky to see where was their consent. And I'm not saying that all breakups are absolved of sexual harassment cases. That's not at all what I'm saying, because sometimes there will be consent, they will be dating, and then one of them, breaks off, the other person is still pursuing them. So that would still be sexual harassment, even though consent may have existed at some point in their relationship. Therefore, I think the best approach is to be open about it and say that if there is an office relationship, keep it respectful, keep it decent, because you are at the workplace at the end of the day. Keep it outside the office and don't let it affect your work, and be transparent about it. Would be my thoughts on it. And Nidhi, the way that I handle being an external member and practicing advocate is that I have limited the number of clients that I take on as an external member. Right? I'm associated with Sasha, and at Sasha you're assigned clients, corporates that you handle as external members. But I have severely limited that to a maximum of 10 at any given point of time, so that I can still go to court and get those dates that I need to. Was there any?
What responding was one Southwest employers basically don't act on degradation to the
Should finish this and then we'll get to that. The other way of doing it also, which I've seen, is they have no office romance policies set in place. That's something also that has come up after the IC has been formed, and they've seen a lot of cases involving relationships gone sour, and then they come to the IC, and then you have to waste so much time, energy, and then you get to know actually that it was false or fabricated complaint. So in that policy, there are two things that they cover. Usually that if you're in or getting into a relationship when both the parties are already in the organization, you inform the HR. What the HR does with that is either separate the parties, meaning branches, like one is sent to another branch and one. But if you can't send them from finance and legal, then probably shift the place or location of one of the parties. By then, most of them break up. But yeah, this is one of the options they give. The other is they ask one of the parties, yeah, just leave now, enough done. So the other is they say that one of the partners will have to leave if this proceeds. That's another reason where it usually breaks up. Yeah, marriage, or many times couples have not informed the organization and gotten married and then come back and informed the organization. That again is not taken very well, where they ask one of them to actually go into another branch which is outside the state or completely different line of work, or you have to leave the organization. Yeah.
Yeah, no, it's interesting. I think being transparent and disclosing relationships really is what I've seen as a trend. But I'm not sure I agree with, peer-to-peer romances and disclosures. For me, it stems from, again, the practice in the US, because the liability of an employer is different. It's looked at differently in, say, in the US, where, you can be sued for not creating conditions safe enough in the workplace for the woman or the individual to feel that, or that you failed in creating a safe enough atmosphere, and that's why I face sexual harassment, right? So in India, it's looked at differently, because there are these specific steps that you need to take, and still it's checked against, do you have an IC? Do you have a policy? Did you do the inquiry? Is your IC composed properly, right? And so if you're able to show these steps are done, I'm not sure yet, I haven't come across any judgment that says you are still liable as an employer for sexual harassment, right? So to my mind, I don't know how effective these disclosures are from a liability perspective. For me, the disclosures work to be able to establish the starting point of consent. And that's really it. Right? Because you, like Nitya said, you don't know when it might break off. But it gives you a point where you can say, because both parties are expected to come forward and sign this, and that you will say, shorn of any later allegation that I felt coerced or I felt compelled, that at the time that you signed a document, that there was valid and appropriately thought through consent. Right? So for me, that is useful as an IC member, but otherwise it's completely irrelevant. On the other side, what it helps organizations do is then recalibrate, rejig their reporting lines and all of that, which is just healthy practice. And so I encourage that and I say, please put more onus on the person who's got higher power to be able, because it's their responsibility after all. Because I will, of course, come and look at you and say, how objective were you? Because are you able to demarcate in your mind your role as a manager and your feelings as a partner? And I will say, I take that decision out of your hands. I'm not going to let you be in any position of dilemma or let the rest of the team members feel resentful, because as much as you can say the two individuals are mature in handling this, you don't know how the rest of the team feels, right? There could be just a sense of resentment. So I say, look, disclosures are good, especially where there's a power relationship. But peer to peer, again, it is, if you want to encourage disclosures, yes, but how comfortable two people feel to come and tell you when, in this day and age, especially when people don't want to label anything, right? What are they going to say? We went on a date, exactly, it's a situation, we went on a date, we went on two, we might.
It's not very more. For months, then you go.
Oh, I see. Well, so, for me, then, it really is not very useful, right? So for me, disclosures work, for some specific reason only. But if that means it's helpful for the organization, well and good. Some questions there. I think Divya.
No, actually, I think it's a take on the third question as to what are the consequences if, there's no action taken. Also, I wanted to ask about the judicial review of at what stage. Like you said, the appeal goes to the Labour Commissioner. That is at the end. Have there been instances in your experience where the respondent has gone on some interim relief, against an interim relief before the Labour Commissioner? And what is the route? Is it like, again, an industrial dispute that is raised, or then, have there been instances where the overarching writ jurisdiction of the High Courts also come in? Something like that, have you come across? And what is the responsibility of the external member when, let's say, a constitution of the committee is questioned, or the fairness of the whole process is questioned? So,
In my experience, I haven't seen that, because there is no provision for them to approach the Labour Commissioner before this is over, right? There's only Section 18 for them to appeal after the recommendations are made or after the report is made. They can't seek any interim relief through the Labour Commissioner in the interim. And even writ jurisdiction, I would assume that the High Court will say, you go finish that and come back. Is my assumption. I haven't seen it in my experience. And for non-implementation of recommendations also, you can still appeal to the Labour Commissioner under Section 18. You could also go to the State Women's Commission if you're a woman and there are recommendations made against the respondent and it's not implemented, or they're not complying with the PoSH policy in its full spirit. Then that is something that you can still go to the State Women's Commission and complain about. And they're pretty active. In fact, they have a website, not the State Women's Commission, the National Women's Commission has a website where you can make a complaint after you speak to the State Commission, if it is not implemented. Yeah.
The government's restriction before you opt to get commission and national commission, we want the fact finding. All reason they do a very, like yes, Apple and the party, they're not communicating that. They only see whether the process that keep following that.
Yeah. Yeah, it's a very high level involvement. They will send you to the appeal authority, or they're supposed to send you to the local complaints committee, which I don't know if it exists in Bangalore.
The data express.
This is just coming back to what we spoke first about workplace romances and all of it. So obviously it's very difficult for an organization, especially larger organizations, to control what is going on, or at least have sight of what's going on within their employees. But have you seen situations where companies do have a policy where whenever you join, at whatever level you join, be it a fresher, be it a mid-hire or a senior level hire that you do, have you seen situations where the policy informs them that if there is an office romance, or if there is something going on which turns into a serious relationship, one of you will be asked to leave?
or one of you will have to, based on performance or whatever the internal decision is. Have you seen situations like this? Because I have heard of law firms where they say that if there are two partners who are, when I say partners, I don't mean at on a professional level. When you do get together and you disclose it, one of you will have to step away from the firm because they're not okay with it. Because we've personally seen situations where, I mean, people are not mature when it comes to their feelings at times. It's not handled very well at work. It makes it uncomfortable for the entire team. So it's altogether better to do away with this in office. There are firms that encourage this. There are firms that encourage, people to get together and grow a relationship within the firm. But there are firms that say otherwise as well. But are there companies that adopt this policy to say that if you come and disclose to me that you all are going to get married, one of you will have to step away? Is that something that's done?
In my experience, no. I haven't seen written down policies amongst my clients. I've seen the opposite, what you described, Sanjana, which is that we encourage them to, stay within, but this comes under the marriage umbrella, right? No one is talking about situations, which are situationships as opposed to marriage. So actually, in general, I think it's quite unfair, right? So I don't know how much you can have it in writing and say that you will be asked to leave. Moving within the organization to, where your influence on the other professionally, right? You take them out of the spheres of influence, that is pretty much done. I think it's de rigueur, but, actually saying to someone, step away now, I have not seen that. I don't know if, Caroline,
Then policy might get challenged.
yeah,
Yeah. So the no romance policy that I was talking about, one of the organizations had this in place, and a couple, workers, colleagues got married, and they hid that from the company for a very, very long time. So she would still pretend like she's going back home and all of that, and they'd meet. And somehow it got out, obviously. And when the organization got to know, they had said, that brought it to their attention that it has been said in the policy which you signed, that if the romance or whatever continues and you get married, one of you will have to leave the organization or will have to step away from that office or that branch of work where your partner is working. So I have seen this once only, but yeah.
Yes.
So much on romance, nice. I'm talking about PoSH.
No, but
So my question was like, after taking so much care, like setting the policy in, and still if you get a complaint from the person, like the complainant, and if she, because the act says that complaint is how the person perceives it. So before when they were in relationship, it was all okay for her, and suddenly when it breaks up, she will say, no, the act says, because how I perceive it now is extremely, hostile for me, and now it's like a sexual harassment for me. Before it wasn't, because that time I was not thinking as a sexual harassment. So how do we deal with it? Even taking care of all these things, policy and everything, how we perceive it, because the act says, if the complainant goes by the definition itself, it will be very difficult to draw a line between, how the person or complainant perceives the particular act as a sexual harassment. So, take all that, please.
So COVID times, we had a case actually, similar to what you're saying. This organization had no policy as such. People could get married within the organization. And these two were working together in the same line of work, same field. And she complained to the internal committee that her husband was actually physically and mentally harassing her at work. And she wanted the IC to actually look into the matter. Now, when a complaint is made, initially only we can't just throw it out saying that this does not fall within the purview. So you have to review it, scrutinize it, and then decide whether it comes or not. So we had to basically break it down. Usually that's how we conduct it, break it down completely and see, instance by instance, event by event, or incident by incident. And when that happened, of course, we had to speak to the complainant a few times before even we could tell that we'll take it up. We did find that, her demeanor, the relationship between the parties, all that had kind of changed during this, whole time. And because of that change in that relationship status, even though they're living under one roof and still married, because of that, and because they were working in the same place, reporting to the same manager, and her work performance actually was going down. She wouldn't be taking calls and all. And there were mails and messages where she has told the manager and named her husband and said that, he's not letting me do this. I'm under a lot of stress and all of that. That's when the IC agreed to take it up, but with caution, of course. So a lot of the elements of the complaint was pulled out and taken as a workplace issue. So we segregated that, we filtered it, and only what we thought was pertaining to SH, we took that up. So I don't know the outcome, what happened to the couple, but yeah, few instances that felt like SH and going by the complainant, it did happen and did take it up.
Registry request after marriage,
This was after the marriage.
then we can, can't we treat it as a domestic violence instead of...
We did, that's what we did, right? So domestic inquiry, not the violence part, I don't know if they went and filed a FIR or what. The domestic inquiry from workplace harassment purview was taken up. So it was, you know how when they are writing a complaint, they're not really clear on 1, 2, 3, this date, time, when, where, why, how, all of that. So we had to segregate it. So that's when we felt there were few of the incidents or events which was sexual harassment because, it was at a workplace and because she's not in the relationship as husband and wife. On those grounds, only those few points were taken by SH. The others were filtered and sent as domestic inquiry by the HRO.
That's why you could take it under the purview of IC.
That's why we took it up, yeah. Not complete, the whole complaint again, we had to filter it down. Yeah.
Sure.
Yeah, I just wanted to add emphasis to what you were saying. See, consent is a very, very, moving, living thing that you have to really step back and factually assess when it exists, when it doesn't. It's not necessary that every sour relationship lacks consent. I had a complainant come to me and say that she was in a romantic relationship with a person and she had even gotten impregnated by this person. But the things that she was telling me is, I got fooled into this relationship. I am really young. I didn't know better. I didn't see the world better. He fooled me into this relationship. He promised me. Now, her belief of those promises might not essentially turn into sexual harassment against the respondent, right? But the internal committee cannot judge this at the initial stage that the complaint comes in. The complaint has to be taken in if there is an element of romance, if there is an element of sexual harassment, and then it's up to the committee how they bifurcate it, like Carolyn said, and take what is sexual harassment and what's not.
Yeah, I think just to round off the discussion, I don't think the relationship or the status of the relationship determines the existence of consent. It's as simple as that. So consent has to be separately and always evaluated. And prima facie, the complaint has come because they are saying there wasn't consent for certain things. So that's the starting point for us. Then it becomes the respondent's responsibility. Of course, we will evaluate and examine, but it becomes the respondent's responsibility to say that no, there was consent, right? And then those are questions of fact that we have to determine. There's an interesting Delhi High Court judgment where, it was between a student and a lecturer. There were texts exchanged, right? And the lecturer said, I don't teach her personally. And she has continued this conversation with me, whether it was flirtatious or suggestive or whatever it was. And the IC said that regardless of what it was, you were still in that position, right? So in fact, it was the other way, saying that your position itself leads me to believe that there was no consent. So we are starting with no consent. So you have to also understand that starting position, where, when, what mindset each one had, and leveling of consent becomes very important. Even in a consensual relationship, you may not have consented to a certain physical act, right? So these are the things where you have to see where it leveled off. It's like establishing almost consensus ad idem. Was there a meeting of the minds? What were you both saying? What was articulated? What was not, right? So that's how we'll have to look at it, I think.
Sorry, I have to run, so can I ask my question? Strictly not, but this was absolutely lovely and I really enjoyed the session. But I think my question comes from your role as external members. Have any of you had experiences where it's been difficult for you as women to have two other panelists who were men and you've had to sort of navigate that and fight the discrimination there and say, I know what I'm doing. Has that happened and how difficult has that been? Because I'm assuming there'll be quite senior guys on the panel, men, women, right away.
No, short answer, no. I think people are either scared or sensitized. So, not really. But I think battling sometimes on, oh, it seems like they encouraged it. I had one instance where this breaking down of each instance of it was actually a question of sexting, and I was of the view that each event ended there. At each night, say that, I was involved in this point, I was agreeable up to this point, but the next day is a fresh start. Not all panel members agreed with me on that. They said once you've agreed to, have this kind of interaction, of course why would I think you've changed your mind, right? But, so I had to battle things like that, but for me, it's been agnostic of gender.
Sometimes. Also, if it is, the organization where they have someone from director level, sometimes I've seen, or HR level also, being an IC member. Yeah, I think that Divya's question about, IC, the constitution of the IC not being right, that is also something this was touching on, where they have questioned that, this is such a trivial matter, I think we should just let it be, let him just give an apology letter, or it is about, he's handling a huge project, we cannot be getting him involved in all of this. This mostly comes from the male, part of it, no offense, but yeah, not all of them, some. So we have faced those, and I think we can tackle it, like we said, no, with experience. I think if you're a starter, yeah, you do get shied away and nervous and all that. But with experience, yeah, we are able to take it. And luckily, because there is an act and all of that, presiding officer always holds an upper hand somehow. It's not written there again, but it is understood. So you use that there, yeah.
This just reminded me of a really funny instance that I want to absolutely share with you all. There was an internal committee inquiry that I was a part of. This was virtual, and the other internal committee members were also online. And one of the internal committee members said something absolutely ludicrous. I don't want to get into it, maybe I'll tell you offline. And my immediate reaction, without my realizing it, this was when I was in my nascent days of being an external member, so I hadn't control over how I felt about certain things, and immediately I rolled my eyes. Okay, in that camera, I rolled my eyes, and immediately after the inquiry, I got a call from this person, and I hadn't realized that until he called me later and said, "I'm so sorry, did I say something wrong? Like, what did I say that was wrong?" And this is one of the senior persons in a company, and I told him that this is not how it must be approached. And like Carolyn says, it's something that you establish over time, but you have to take control of how the dialogue is going, because no matter the amount of capacity building, skill building sessions you do, I find that internal committee members can be really insensitive, abrasive, judgmental, biased, and that's something that you have to keep slapping them on their wrists and sort of bringing back to the table.
Sorry, just as an extension to that, my question was, so we spoke about how there's a lack of an organized body that gives a certification to who can be members of the IC. Would you then suggest an amendment to the Act itself, laying down qualifications and maybe even including specifically lawyers or legal professionals, or would that narrow down the scope of the Act? Because to begin with, sexual harassment complaints are still, they're also not complying with the Act and also very difficult to approach. Would that be narrowing down the scope of the Act? And just a second question would be, just broadly, what and all would you say will fall under sexual harassment? Like, for example, would incessant texting also fall under sexual harassment against women? That's all I wanted to ask. Thank you.
So, good question. I think, I don't think that for internal committee members right now, there's no requirement that you need to be a lawyer. Just, I think, familiarity or knowledge, right, and some sensitization, that's what is needed. I think we should stick to that. For composition of the local committee, of course, specifically it says lawyer, and I think that Air France judgment, also touched upon this. So I don't think so, because I think as much advantage as lawyers bring, we are also, our perspective also is not always right. Yeah, so I have seen that, right? And you need more voices at the table. And believe me, as much as we feel that, there's this legislation and it's the automatic domain of lawyers, and then, it was the Vishakha judgment that sort of started it all, and again, Supreme Court, the people who went to court were not all lawyers, right? So I think their views and their worldviews, and I think it's important to recognize that, and they bring a very different approach to what we look at resolution and what they look at resolution. And sometimes lawyers can become very focused on the problem, amidst the woods for the trees, or vice versa, whatever that is. And so it's important. So I wouldn't agree at all. I mean, certifications look, it's very nebulous. I don't, at this point, think it's necessary. I'll just answer the question and, wait if anyone else has on the idea of what constitutes sexual harassment. For me, two key things, right? And this is, I think, unwelcome behavior of a sexual nature. Whether it's obviously of sexual nature, whether it's sexually colored, what shades of gray, that's perception based, right? And what is sexual is the big, because unwelcome, you have to take at face value. If it's unwelcome to me, whether I find it forced, whether objectively it's unwelcome because you can have a code of conduct, all of that, right? To some extent, it's easy. For me, the way I have learned to analyze this is questions of intimacy also. Behavior that is sort of a prelude to greater intimacy, which imposes an intimacy, which seeks intimacy, right? It can be physical, it can be more subtle than that, it can be more from a sharing perspective. Wherever I feel the question is, why are you asking me this? Why are you saying this to me? Why are you doing, what is the context of this, right? Of course, it depends on gender as well, right? But where that question comes is, I think, for me, it goes into the realm of sexual. That's how I have analyzed it. Otherwise, the law is very, very open in terms of, like I said, inclusive and verbal, non-verbal, behavior and all of that as well.
No, I agree with her, yeah. And it's still very gray to tell what is sexual and not sexual. We can't really put it in words because what's okay by you may not be okay by me. So it's only just about perception.
Yeah, that's. I think that pretty much covers what you were asking.
Just to add, though, the confusion comes when things are sexist but not sexual. We feel we are forced in many situations to distinguish because, it's been a mixed bag in terms of judgments. Sex-based discrimination, the Kerala High Court, division bench judgment has sort of clarified, saying sex-based discrimination is not necessarily sexual harassment, because if you don't have a sexual element to that kind of behavior, it's just discrimination. So, but it's facts and circumstances of each case can differ. Other questions?
So my question pertains to the inquiry once a complaint comes. One of the things that was said was that at the time of inquiry, witness statements have to be shared with the respondent. But what happens when the witness statements or the witnesses request anonymity? Because principles of natural justice still need to be followed.
So what I do is I edit the witness statements to remove all the details of the witnesses and specifics about the incidents, and I give an abridged version of the witness statement to the respondent. That's how I deal with it. But of course, at the end of the day, complete anonymity is still at risk, because based on what a person is saying and the tonality of their language, the other person could decipher what is going on. So another measure for protection is, in one of the cases, in fact, where there was a workplace harassment and not sexual place harassment that I was investigating, witnesses were terrified of the respondent, and the respondent was at a level that was much superior, right, like the head of the company, and they were terrified. They were even refusing to give these statements. So I had to assure them that they will get absolute and complete anonymity, and took those statements. And then I have justified in my report that based on, I think it was a Delhi High Court judgment, which says that yes, principles of natural justice must be followed, but as long as the respondent has the main crux of the issue, you don't have to sort of nitpick and see if the witness's statements, you can justify not sharing a certain witness statement if the witness is at risk.
Sorry, Nitya, just to clarify, you don't share the identity, but you share the statement. Is that okay?
Usually I would bridge it. In a exceptional case where there was risk to the witness that they were refusing to even speak, and it was really necessary for it to be investigated. Again, to distinguish, this was not sexual harassment, it was workplace harassment. Then I have even retracted those statements. I haven't shared it with the other side at all by justifying it on the basis of a case law.
Yeah, my reading of the Delhi High Court judgment was that it was promising anonymity to the witnesses. It was in the context of SH, I think Justice Geeta Mittal, if I'm not wrong. So I think in that particular case, they said that the names and the identifiers of the witnesses could be hidden and the inquiry process could continue. There are circumstances, I mean, prior to, now there's more monitoring of how we work the inquiries, right? I think in the heydays of just the Vishakha, we've all used the procedures the way we thought would be most fair. But I still, I'm not actually in favor of either redacting the names or, because there's no guarantee that they will not come to know, right? And I believe that you cannot fully defend yourself until and unless you know who is testifying against you, to put it that way. Because if I have to then challenge that, I also need to know the place of bias where they may be coming from, what my interactions with that person have been or not been. Are they giving an objective standard? Are they sort of eyewitnesses in the sense, were they present? Or this is about something else, So there are various, I would feel very hard done by if in the place of a respondent or even a complainant, right? Details of the individuals who are testifying against me were not revealed to me. I would make that a ground for challenge for sure, right? So I'm, to be honest, not in favor of that. I do try and assure non-retaliation. I do, we as almost even in policies now, I write that if either the complainant or any of the witnesses is uncomfortable facing in-person cross-examination or any kind of interaction, that we will not put you in a room together. That's something I almost off the bat, I assure everyone, saying that we will never force you in the room together. We will manage this, as even if it means we go back and forth, we do. Only where the witness or the complainant is absolutely comfortable. Even then we say, as a respondent, do not, you can be present, you can ask follow-up questions by text, just, so don't, look to intimidate, etc. But, we'll have to see the facts and circumstances. Ordinarily, I wouldn't advocate for anonymity, right? That's what I would say.
Yeah, I agree, Shruti, and the judgment that I was referring to was not Geeta Mittal's on anonymity of witness, but it was, I will get back to you on what exactly the judgment was, but there is a judgment that says that in such cases, principles of natural justice is not absolute, and you can make exceptions and sort of, in order to protect the anonymity of the witness, withhold the statements from being circulated to the respondent. Yeah, but if, again, like Shruti says, depending on, is this an eyewitness, is this a witness, a circumstantial witness, or a witness who's just generally testifying to the nature of a person's behavior in the office, and they say that we're absolutely scared and we want anonymity, in those cases, I have, in fact, sort of just shared a statement without identification of the witness itself.
In one matter, what we did was we went to the extent of actually the party signing an NDA, which included, even though there was a policy on non-retaliation and confidentiality, and when you summon them, you again reiterate time and again about maintaining that. Before the witness could come forward because of, the person being terrified, we asked the party to sign a non-confidentiality, NDA, sorry, not non-confidentiality, agreement, which spoke about there could be action taken in case they acted against the witnesses or any other party.
So my question is basically, because there's no legal representation through the process, do you then take on that responsibility of explaining to both parties how to put down their complaint, what to annex, what emails, whom they can call on as witnesses? And also, is it like a process of framing issues where you explain to them that this are the instances that you will have to explain yourself? And after the evidence process is done, say there is a cross-examination, is there another opportunity for them to then present something in the lines of an argument to explain what has come come across through the entire inquiry process. And my another question I had was, if through this process it becomes daunting, as I imagine it would, and the complainant wishes to withdraw their complaint, is there any measure that you can take that prima facie it appears that this has happened or this has not happened? And so, even though it might not be a report that you submit at the end of the process, you can suggest that because the benefit of doubt lies with one party, maybe the other party has to be transferred, or the other party has to suffer whatever consequence it is, even if there is a withdrawal. And if somebody is convicted of, or not convicted, but is held responsible, is there some sort of repeat offender, or like, is there a database where, okay, those were my questions.
Do you want? Sure. Okay, so there were a whole lot of questions. I'm going to try and remember what those were. One, your initial question was that in an inquiry,
So without people,
yeah, without legal representation, how do you, at the beginning of an inquiry, you explain the rights of the complainant to them about, non-retaliation, like Shruti said, confidentiality, their ability to approach the police, and transparency, fairness, etc. Same thing you do with the respondent also. You tell them that if they have any questions, they can get back to us. And sometimes we also tell them how this is going to play out. And in the show cause notice that we issue to the respondents, we do frame charges based on what the allegations are against the respondent. So they can answer it based on the charges that are leveled against them.
they then argue that
Yes, so at every stage, even after the report is prepared, it is shared with the parties, and they are asked what they think about it. Even before we do the report, we set up a meeting with the respondent and the complainant, and have them talk to the committee as they will, use that half an hour or 1 hour to tell us what they think, like arguments of sort. And after the report also, they have a chance to get back on what they are not agreeable with in the report, and we have to address that and then make the final inquiry report. Okay, the first report is the findings report, where we say these are the findings, and we circulate it to the parties. The parties will then have an opportunity to rebut that, and then we make the final inquiry report, addressing whatever counter they may have to the findings that are made.
yeah.
Yeah.
And they claim to withdraw the time free, so we take this at lunch, maybe at least more questions.
Sure.
My process, but maybe they can take this with you. Sure. And you should get it.
Hi. First one is out of curiosity, just if you guys have been external members in like situations of law firms and circles, this is mainly coming from a point where I see, despite us being lawyers and being aware, in my limited experience, I feel that whenever there is a circumstance like this, it's still kind of hushed upon. Like there's not an environment where it fosters, say, a complainant or complainant to be, to go ahead and sort of, complain against an instance. And that's something that I still don't understand, why there's a lot of stigma and shame even in the law community, right? Like to sort of take it up, and if something can be done, to make sure that the environment is better. And the second one, maybe I can discuss later, but once a complainant does, as a part of being external member, how do you guys, to what extent do you support the complainant in cases where she requires, or how do you deal with situations where, say, of course there is some interim measure given to her, but I'm guessing it's not as easy as that, right? Like she may be having a lot more issues to being in the company at that point and stuff like that. And how does one deal like in circumstances like that?
The law firms I've seen, as an external member, you are truly external. So often, many of the things that happen, you don't know, right? Having said that, I think when you, as much as possible, right, as an external member, the way I have looked at it, I have to trust that the committee, other committee members are robust and equally interested in protecting the process more than the organization, right? And so that's how I choose my clients, or how I agree, right, where I know. So from my experience, I have not seen any hushing up or anything as such. I think what is important is, to recognize what other, because there is agency under this act, right? It's one way to resolve. And we are, to some extent, as committee members, hampered by the fact that a lack of a written complaint under, or specifically under the PoSH route, means that we are not activated. The IC does not have, no suo moto, no anonymous complaints, no oral complaints we can act on. But it means then that we can still offer them other options, under the code of conduct, under the general. So for me, if as a committee you're at least encouraging the organization to act in some way, even if not under the PoSH route, I think that is an important measure for me, right? But it's different. Different people have different experiences as to how they perceive the system, right? And I think the Me Too movement was essentially that for me, that we have no faith in, we have had to resort to social media because no one has ever heard us before. So I think that's my appeal to organizations: solve for this, right? Make sure there are people there to hear people. Nobody cares whether they go under the PoSH route or the workplace sexual, any other route. It's really irrelevant. Many people don't even want any disciplinary action. They just want the behavior to stop. So solve for these things rather than getting involved in all the technicalities. So I think where there are generally, whether it's law firms, whether it's organizations, where there are cultures set up to be sensitized, you will see better responses. Where there are not, even responses like, let's get rid of both of them. I've seen both. I have seen both. If
Challenge.
Yeah.
Trainings also helps.
Just to add to what Shruti said, also trainings and awareness in institutions or organizations helps and goes a long way. Your posters where you're making them aware of the IC, just building that faith in the employees that, it's not just the people from the organization, there are from outside, which is the external members' role. So that also helps a lot, actually.
Yeah, good one. Just saying. That's if there's one question, they think I might have said anything. After this, we take Joanne, we may not.
As an external member, I have come across a situation recently, because nowadays all these startup companies are coming up, and after work they move on to office parties, and then they move on to their private parties where the incident happens. So this workplace definition, which is expanded, so can that be expanded to the private party which goes on in an apartment? Or there are the employees, but they would have moved on to a private place. No. Yeah.
Employees and work.
Because they are working together, that's how they got to know each other, right? That basis is more than enough. And even if you're saying in this private party there are only 3 employees, and they get friends from outside who are unknown, and still something happens, it will still be taken as workplace sexual harassment. Yeah.
And one more thing. I would want to know, because as an external member, I have been asked to do everything, right from the beginning to the end. And the members who are there in the committee, they just sit saying that we don't have any experience in these sort of matters. So where do we...
like I said, it's how much you take. Yeah, so they do try and push, but how much you take is what is important.
As a lawyer, they say, oh, you're a lawyer, you know everything about this law, so you have to do everything, maybe even from the point of, taking the complaint and talking to the complainant and then issuing the show cause notice, then going on to, setting up the committee meetings. Some things, very minor things, the other members will do or the HR will do, but everything else you are expected to do. So your experience as members.
Actually, a lot of the role, so actually primarily the role is for the presiding officer to take on, not the external member. So the summons that you're talking about and, calling for inquiry, having meetings, trainings, all that, it's done by the presiding officer or the management. Now, when you talk about the drafting of the inquiry, because you have the legal backing and all that, they prefer lawyers, which is fair enough. But calling parties and questioning also is, all parties, most times it's external who's asking. But yeah, I think you need to segregate the presiding officer's role, because she actually is a one-point contact, not the external.
Yeah, that's right.
So, just to add a little bit of nuance to Caroline's answer to the extension of the workplace, right? I think, of course, one test is to see what is their relationship, why they ended up in that place, whether it's because they were employees or they knew each other at employees. To my mind, it's one test. For me, the other test is to see whether whatever incident happened at a private function, does it have an impact in the workplace, right? And that is separate from their status as employees, right? So I think that is the additional question we ask, and sometimes we have to say it's a private event, right? And employers are wary of extending it to an unnatural extent where they say, look, we did not sanction this. We have no control over people's actions. We have no control over the premises. So why are you making us take responsibility for this? And then it's not so much the incident.
Getting,
Yeah.
see, as it is, we have a Dutch problem child. Why should we get it?
Yeah, then you have to see whether there is a more likelihood than not that there will be an impact on the workplace relationship between the two individuals in terms of hostility or in terms of any other, negative impact, right? So that is also a key element that we take into account, whether, we can extend the definition of workplace to absolutely private events.
I may be going a little beyond the scope, but what does the panel think about an amendment to the Act now that people are identifying themselves in the spectrum?
See, the reason that it is gender specific is based, I believe, on statistics about how women were statistically facing this. But the positive thing is corporates have, even though the law is itself gender specific, they have moved to a more gender neutral approach. And it's not just heterosexual male, female that can approach, but literally everybody can. That's where it's at now. Whether or not that amendment is going to come about is, I think it's in parity with the rights of the LGBTQ, which is very abysmal in our country right now, except for decriminalization of 370. Yeah, 370 was it? So, I don't know. I don't have any visibility on when that amendment is going to come about.
I think, Rights of Transgender Persons Act asks for a complaints officer to be set up. Now, that's not as widely known as the PoSH Act is, right? To some extent, instead of setting up a separate complaints officer, although in name you can have that, giving the IC more, because generally in terms of sensitization, if they already have the training, I think it's better, right? Having said that, the gender identity is different from sexual orientation, right? And so there's nothing in this act that talks about sexual orientation. So we need to make that clear. What it's the gender of the person, and gender identity isn't spoken of more very specifically. But I think there's a Madras High Court judgment. There's a statute in Tamil Nadu, which looked at not about the harassment of women, not sexual harassment. And there, a single judge bench held that a person identifying as a woman can also approach under that statute. So you extend that, I'm okay with that, right? So I think, anyway, sexual orientation needs to be kept out of it, because that's not something ever the Act has demanded that I should be, I ought to be or I'm not. Otherwise, I agree with Nitya. I mean, it's about being inclusive. And for me, it's, I think, more than the mechanism, or do you have an effective mechanism? It need not be under the PoSH Act. It need not be under any specific statute. But do you still have a believable, trustworthy, neutral, non-judgmental mechanism? I think that is very important. But if it comes through PoSH, like I said, women have fought for this. I believe we can be generous to say, these rights and these protections are for everyone.
So I was just curious, how do you deal with complaints where, there's a gray area because, say, alcohol was involved, a so-called gray area. And I'll just use heteronormative terms here, but mostly it'll be a guy whose defense will be that he was under the influence of alcohol and he thought that there was consent and, or he doesn't remember what happened. how do you differentiate what's happened in such situations?
Irrelevant points. I mean, was he forced to consume alcohol? No. So I mean, basically, if he was not forced, he's still responsible for his actions. Whether he remembers, whether he had imbibed alcohol or any other substance to the extent that he lost control of his actions, not the.
I'm not on the point of losing control, but perceived consent. So where both people are drinking, say they've drunk quite a bit, and there hasn't been a no from the other side.
Okay.
So, because I've seen this happen a lot. The defense is usually, I drank alcohol. I didn't really know what was happening. She didn't say no. She seemed she was into it as well. So, but I mean, the next day is when the complaint comes out, and
so to my mind, I would have to take what the complainant is saying at face value, right? Whether they were in a position to articulate their consent or lack of it becomes an issue, right? I have dealt with cases like this where the man or the respondent has said, and I have dealt with cases where they were always men, right? I was too drunk, I don't remember, and I thought, they were okay with it. Or just flat out said blackout, I was so drunk, I just don't remember. I said, sorry, that's not something that will absolve you. You thought there was consent, that's a separate point we deal with. This on its own will not absolve you. Then we looked at whether the complainant was in a position to express consent, right? And there also we have to see whether the alcohol consumption was voluntary or was there some force or pressure, because these are issues also. And then we have to say, the establishing of consent is always a tricky question, whether the alcohol is involved or not. So that we have to deal with independently. Did you articulate? Did you not? And then we go step by step, right? So for example, this is completely hypothetical. What did they say yes to? Did they say yes to dancing with you? So that's just that then, not something else. So I think you have to sort of break it down and say, how did that happen? And sometimes, yes, we have to probably accept defeat in the sense that say this is not substantiated. Not only is it not substantiated, it's actually inconclusive. As much as I agree with Nitya who said there are 3 outcomes, there's also a 4th, which is that on the specific issues you identify, often you end up saying it's inconclusive. And while you clearly say, I'm not saying either of you has lied, it's just that there isn't enough to satisfy us either way, to say it's substantiated or not. Yeah, later what you do with it is a different question.
That line where you say...
Sorry, where's the line where you say?
It's the line that you got where you say that you don't work.
It would depend on are you able to establish, lack of consent, that it was vocalized, verbalized, or was there some behavior, in some cases, we have had help from witnesses. Like in one case where I'm talking about, the witnesses were able to say that, although the 2 parties involved seemed too inebriated, there was enough of, maybe compulsion, maybe, a lack of complete consent there. So then you take that on board. But, I can't say definitively where objectively you can draw the line. I wouldn't be able to say that.
That's very difficult. But I agree with what they said, yeah. Same thing we apply.
To let the panel go for a while. They're going to be here for lunch. Please join us for lunch. This has been a good, very good session. In fact, just to take off on Meghna's question, there was, while it was not a PoSH cause, if you recall, there was that particular High Court judgment which said that a feeble no is also a yes. So on those infamous lines, hopefully the PoSH committees put in a lot more introspection than, unfortunately, that High Court judgment. Thank you so much for being part of this session, and I'm sure our audience have a few more questions. Please join us for lunch, and thank you. See you soon.